Oh, by the way, Judge, I forgot to bring... Judge, I'm here, but take my word for it as to what I'm telling you. But Judge, I forgot to bring the case law to show you as I'm supposed to do. And also, Judge, it's worth pointing out to you, there's another 7 members of my team that are all licensed practicing lawyers, and we're all very well and handsomely paid, but we forgot to bring the case law. It's almost unbelievable. I mean, Hey, my friends, Jared Duke's back with you. I want to welcome all my free-minded friends out there. We are in the middle of looking into the incompetence, absolute incompetence of attorney Nathan Wade, who, of course, is the lead prosecutor in the so-called Trump RICO case out of the Fulton County DA's office, which, of course, is ran by sweet Fani Willis. And obviously, we know what's been going on between Fani Willis and attorney Nathan Wade. This particular video that we are in the middle of looking at is something that just spells out for all of us to see with our own eyes and hear with our own ears, and it shows just how incompetent Nathan Wade is. It is very clear as we watch this together that he has no idea what he is doing. Now, remember, when this particular video was shot in court, it was either the first or second hearing that the court entertained in this RICO matter. So what you got to remember is at this time, the judge and the defense attorneys, and for the most part, the prosecution team, had no idea that Nathan Wade was essentially in this corruption scheme with Fani Willis, at least to the best of our knowledge. The main thing to take away is that the judge definitely did not know this guy was essentially a novice, a fraud, if you will, but portraying himself as someone that can handle a RICO case, because this guy is just not a RICO guy. But let's get right into it and let's take a look at it. Okay, here we go.
First, if the pre-indictment proceedings were made public, many prospective witnesses would be hesitant to come forward and voluntarily, knowingly, and those against whom they testify would be aware of their testimony. That's the first thing.
A real quick piece of background so that you can remember where we left off. This particular hearing is concerning 3 motions: a motion to speak to the grand jurors, a motion to unseal grand jury transcripts, and third, a motion to disclose co-conspirators. What you need to understand is they're in the middle of arguing these motions, and you're going to see firsthand Nathan Wade does not know what he's talking about. He is going to go on and on about the difference in a grand jury and a special grand jury. He's going to say, oh, Judge, there's no difference. I mean, an idiot knows there's a difference in a grand jury and a special grand jury. Why would you call them something different if they didn't have differences? But this is what Nathan Wade apparently does not understand. So just keep that in mind as we go through this here, and I will narrate as we go along so you can learn from this. So here we go.
Second factor against releasing the information is witnesses who appeared before the grand jury would be less likely to testify fully and frankly, as they would be open to retribution and also to inducements, which we've seen a little bit of in this case. Third, there also would be the risk that those about to be indicted would flee, or fourth, would try to influence individual grand jurors to vote against indictment.
He's just reading out of a textbook pertaining to grand jurors. He's not doing anything exceptional or special. It's not like he did major legal research. He's just reading out of essentially what sounds like a textbook to me.
5, and finally, by preserving the secrecy of the proceedings, we assume the persons who are accused but exonerated by the grand jury will not be held up to public ridicule. Those are factors, Judge, that the court should consider in determining whether or not grand jury secrecy provision has been overridden by counsel's arguments. Don't believe, Judge, that the defense has relied on any case that would override those factors, but moreover, any treatise.
Does this sound like a man worth $1 million? Does this sound like an individual that knows what he's talking about? Does this sound like the leader of a RICO case that's going after the former president of the United States? What is going on here?
That would assist upon them in their reliance, Judge. They did cite to the Gwinnett County case, Judge. And even in that case, the requirement that secrecy be maintained among all types of grand juries without distinction. And that's in the report, a copy of that case.
Take your time, Nathan. There's no rush here.
I apologize, Judge. I didn't bring the court a copy of that Gwinnett County grand jury case, but that's the case.
Oh my goodness, folks! Please make sure you understand this. This is important. You have the lead prosecutor of this RICO action, attorney Nathan Wade. He's paid the big dollars, depending on who you believe or what report you're listening to. It's between $728,000 to $1 million to date as of the date of making this video. And he tells the judge, I want to make a point to defend my position. Oh, by the way, Judge, I forgot to bring... Judge, I'm here, but take my word for it as to what I'm telling you. But Judge, I forgot to bring the case law to show you as I'm supposed to do. And also, Judge, it's worth pointing out to you, there's another 7 members of my team that are all licensed practicing lawyers, and we're all very well and handsomely paid. But we forgot to bring the case law. It's almost unbelievable. I mean, what an outrage.
Case that counsel relied upon and cited in its brief and even in its argument today. But that case is found at 284 Georgia 510, and it stands for the proposition that the requirement that secrecy be maintained among all types. It says all types of grand juries without distinction.
You're going to find out.
So again,
he's
the
given the wrong information.
To the court that there's no difference.
All right. So obviously I'll take a closer look at all the cases you've given me. And I think just as an initial reaction, you're probably right when it goes to saying everything should be turned over. But I want to drill down a little bit more on the witnesses who maybe at this point already you know that you're going to call in November, right? I think that's the whole point of our...
Yeah, let me give you my initial observations on behalf of the judge. I'm outraged. Absolutely outraged. This type of man was put in this type of position and went after good people like Donald Trump and the other individuals he hammered.
Order here, and what we try to do is that we need to use our trial days efficiently and use our jurors' time efficiently. And I would imagine that the state is going to have an order of proof going into this trial with a list of witnesses. And if there are witnesses that are on there, the idea of waiting until the minute before they're called, and then we've got to now pause the trial for an hour or two while then they're reading the transcript, I don't think we can do that. Would you agree?
I agree, and I understand that, Judge. The state wasn't intended to convey that it would hold on to a particular witness's transcript until the eve of trial.
Yeah, you did.
We're still obviously going through receiving the transcripts, Judge. We don't even have every one of the transcripts. And so we're still going through that process as well. But I don't think that the court has made an unreasonable suggestion that the state not essentially implied that the state would not hold on to the transcript until the 11th hour. That's not our plan, and that's not how we...
So I would think at a bare minimum, and maybe we can talk about whether we have to move that timeline at all, but your witness list is going to be due 10 days beforehand.
Yes, sir.
And so in conjunction with that, I would think that any witness on there who has a transcript, that needs to be either expedited or rushed and also provided at that same time. And if the issue comes up that, well, we didn't put a witness on that 10-day list, but now we think we need to call them, unless it's for a rebuttal or some new issue that's come up during trial, I'm going to be looking at that and really wondering if a good faith effort has been made to turn everything over. So I think not only what the defense counsel was referring to, but I think that's what we have to do to proceed efficiently at trial.
Yes, sir. Yes, sir. And there's no argument or disagreement. I think that the court is being reasonable there. But while we're talking about that discovery, we believe that we're still in line with the court's scheduling order as it relates to discovery. So
the scheduling order is just basically the judge has set forth exactly how the trial is to proceed, what they're supposed to turn over, and when they're supposed to do this.
So standing.
Yeah, well, and we'll talk about that at the end. Let's get through the motions first, and we can get more into discovery. But generally, I would think this case is obviously different, but the state's open file policy traditionally has been, here's everything we have, unless there's some kind of state secret or a confidential informant or something along those lines.
Yeah.
Imagine a judge having to remind the prosecutor that it's always been the practice before that the state has a open policy. We're going to give you all the discovery as they're supposed to, so that the defense can look through it and see what kind of evidence they can find that helps their client. So there's not supposed to be any surprise, folks, when you go to trial. So the judge is very gentle here, but I want to make sure you understand exactly what he's telling him. He's like, I'm going to be watching you. You need to be turning this stuff over.
And you have everything that we have, and here we go.
Yes, sir.
So I don't know if that's going to be the spirit that we proceed with here. It might streamline things somewhat, and we'll see where it goes. Any thoughts or reactions to that?
Oh, it is a spirit, Judge. The district attorney has been clear in our instruction.
The district attorney has been clear in our instruction, aka my lover, the person that I am engaged in corruption with, aka District Attorney Fani Willis, has been clear, Judge. Yeah, right.
To make information available to them as it becomes available to us. We are here prepared today to turn over portions of the discovery to the two defendants that are going to proceed with trial on the 23rd. Obviously, we plan to supplement that discovery as we go along and as we receive the information, but we've made a good faith effort in complying and being reasonable and working with defense counsel, and we'll continue to do that.
All right. And when it comes to supplementing it, I would think that's going to be confined to new discovery.
Yes, sir.
Stuff you don't have right now, right?
Stuff we don't have right now. Yes.
So I think for purposes of the motion, let's see, to unseal, I'll take it under advisement as it concerns the entirety of the record or anything that happened there. And as an initial thought, at a minimum, it's going to be granted in part as to any witnesses the state plans to disclose.
Yes,
Of course.
All right. Anything else, Mr. Rafferty?
A couple comments I want
Sure.
to make in response to the argument of Mr. Wade.
And he's about to rip into
Cited
it.
to a Supreme Court case, Douglas Oil versus Petrol Stops Northwest, a Supreme Court case. It cites to Rule 6E of the Federal Rules of Criminal Procedure. The problem with that case, Your Honor, and the case he cited is it has to do with the use of grand jury.
I want to make sure you understand this. He's going to tell the judge straight up that the cases that the prosecutor, Nathan Wade, has been citing does not apply in this particular situation. This guy is an idiot.
Transcripts in a civil proceeding, which I know Your Honor knows, grand jury transcripts in the federal courts as part of a criminal investigation can't just be turned over in civil cases. And so the case he cites has to do with whether or not, and under what circumstances, grand jury transcripts from a criminal investigation that results in an indictment can be used by civil practitioners in a civil case. That has nothing to do with this case. And the point I'm making with this, Your Honor, is this. The government has now cited to a case that really has nothing to do with this.
Yeah. See, there's a difference between civil cases and criminal cases. Civil cases, of course, generally have to do with money. And then, of course, criminal cases has to do with your freedom. He's citing civil law in a criminal matter. It's just apples and oranges, folks. And Nathan Wade should have known this.
They come to court here today. They don't respond to the motions in writing. They drop some motions on defense counsel, or some cases, I should say. They don't put anything in writing, and they just say things to Your Honor. And that's a troubling practice for me as somebody who practices mostly in federal court.
That is not the correct practice, is what he's telling the judge. Normally, everything is in writing as it's supposed to be. You're supposed to sign your pleadings. They're not doing that. They're supposed to give the other side copies of everything, especially in federal court. Federal court, they will not allow any type of error or any type of practice that is not normal and customary. Now, the judge is going to lightly slap back at this, but I can assure you that Nathan Wade is on the chopping block here. He's getting a slight scolding from the judge. The judge is bending over backwards to try to help Nathan Wade because he doesn't want to embarrass this prosecutor on national television.
This is a serious case.
I think you have to realize, I think that might be the standard practice in this building.
I understand that, Your Honor, but I look behind me and I see eight folks here on the government side. We're talking about a case that is unique, to say the least, involving allegations related to the supremacy clause, First Amendment rights, all kinds of things. Defense counsel are writing motions. I think we're at least entitled to a written response from the government citing these cases so that we have an opportunity to inspect them. Because otherwise, what happens is the government comes in, cites to a case that has no application whatsoever, and suggests to Your Honor that it is precedent on that governs the disclosure of grand jury transcripts when it does not. And so my concern and my request is that, and I filed a motion last night where I specifically asked the court to order the government to respond in writing, so that we have a chance to look at these cases before we come to court here today. That's my request.
So, Mr. Rafferty, I think that obviously some of this going back and forth will be touch and go, but I think what we could easily do today and going forward as well, not every motion may require that, but we can always say if a party wants post-hearing briefing, we'll do that. I'm not intending to rule from the bench on a lot of these complicated issues. I mean, I've handed a stack of cases and I'm going to read them, and we're going to have time to get through it. It's going to be an expedited timeline, but I'm certainly going to give you the opportunity to respond.
Folks, what an absolute outrage that Fani Willis was able to put such an incompetent prosecutor in charge of this RICO case. She bypassed the norm. She was supposed to go to the Fulton County Board of Commissioners and say, hey, I want to hire a special prosecutor. There's a reason why they do this, because they don't want the problem that's existing now to actually be a real problem in reality the way it is today. She was supposed to go to the board, say, hey, I need a special prosecutor. I want to spend $1 million. Please allow me to do this. And then they vet the person and make sure he has the credentials and that this is legit and everything's up and up. Because, folks, this is taxpayer dollars. This is your money. This is my money, especially if you live in the state of Georgia. And it's also federal money because apparently she has used COVID funds to pay Nathan Wade. So she bypasses the rules. It was brought up before the judge, and the judge said, okay, well, it's no big deal. I'll allow it anyways, which was a mistake on the part of this judge. But clearly, Mr. Nathan Wade is incompetent, has no business in the court handling felony cases, for sure, and definitely no RICO case. What an outrage. What do you think about this, folks? Please put in the comments and let me know. And if you're still with me, hit the thumbs up button. Be sure to subscribe, like, share. Definitely share this with folks that are suffering the disease of indoctrination, because I'm here to stop it. I'm going to help shed a light on all this nonsense that's going on so that when you understand better, you can live a better life. Now, I'll be coming out with part number 5 soon, showing more incompetence of attorney Nathan Wade. I definitely appreciate you joining me today. It is always my pleasure. I always say, folks, keep that mind free, never give up. And until next time, I am J.R. Dukes.